ICE just put 33,000 names on California's desk. That's 33,000 individuals sitting in state custody right now, and the feds want Governor Newsom to hold them for deportation. But here's the problem. California's sanctuary laws say no. The letter dropped February 4th from ICE Director Todd Lyons to Attorney General Rob Bonta, and it reads like a legal threat wrapped in a public safety warning. People charged with serious crimes, including homicides, sexual offenses, gang-related activities, all part of this detainer list. And if California refuses, we could see mass releases or federal enforcement actions starting soon. This isn't a drill. This is the biggest federal state immigration showdown since the Trump administration took office. And what happens next affects every single Californian, whether you realize it or not. Look, I know you're tired of political videos that just scream at you with one side of the story. You're tired of people telling you what to think instead of giving you the actual facts so you can make up your own mind. That's exactly why this channel exists. I'm going to walk you through what's actually in this letter, what both sides are really saying, what the numbers actually show, and what this means for your community. No spin, no propaganda, just the information you need to understand what's happening in your state. If that sounds like something you want more of, go ahead and hit that subscribe button right now because we're diving deep into California politics every single week, and I promise you won't get this level of detail anywhere else. All right, let's get into it. Here's what you won't hear from the mainstream outlets covering this story. Both sides are partially right and partially misleading at the exact same time. ICE is correct that California's sanctuary laws prevent local jails from cooperating with federal detainer requests. That's just a fact. But California is also correct that they've been transferring serious offenders to federal custody for years, and the federal government keeps failing to pick them up. The real story here isn't just about ideology or politics. It's about coordination failure between two massive government systems that are supposed to protect public safety but can't seem to get on the same page. The political threat here is enormous. If Newsom refuses this demand, expect federal funding cuts targeting California law enforcement grants, disaster relief funds, and possibly highway dollars. We're talking about billions of dollars at stake. But if he complies and starts honoring every single detainer request, he fractures his progressive base heading into a potential 2028 presidential run. He's stuck between federal pressure and state politics, and there's no clean way out. The economic piece matters too. Understanding this standoff means you'll see the next wave of county-level rebellions coming before they happen. Some California sheriffs are already breaking with Sacramento on sanctuary policies. If federal pressure increases, expect more counties to flip, which means immigration enforcement will look completely different depending on which side of the county line you live on. Your zip code might determine whether local police cooperate with ICE or refuse to. And let me bust one myth right now because I keep hearing this everywhere. California is not a lawless sanctuary zone that refuses all cooperation with immigration enforcement. That's just not true. The state has transferred over 12,000 individuals to ICE custody since 2019. Let me say that again, 12,000 people. The issue isn't whether California cooperates at all. The issue is scope. California will cooperate for serious violent offenders but refuses to hold people on minor charges or civil immigration violations. That's a policy choice you can agree or disagree with. But it's not the same thing as total non-cooperation. So let's talk about what's actually in this letter because the details matter here. On February 4th, 2026, ICE Acting Director Todd Lyons sent a formal letter to California Attorney General Rob Bonta. The letter lists 33,179 individuals currently in state custody who have active ICE detainers filed against them. Now, what's a detainer? A detainer is a federal request asking local jails to hold someone for up to 48 extra hours after their scheduled release, so ICE can pick them up for deportation proceedings. It's not a warrant, it's not a court order, it's a request. And under California's sanctuary law, Senate Bill 54, counties aren't required to honor that request unless ICE provides an actual judicial warrant signed by a judge. Lyons' letter uses some pretty strong language. He calls California's approach dangerous and warns that releasing these individuals puts lives at risk. The letter includes a detailed crime breakdown, and this is where things get serious. 399 individuals on this list have homicide-related charges. 1,293 have sexual offense charges. Over 2,300 have weapons violations, and there are thousands more for assault, drugs, DUI, domestic violence, you name it. Now here's why this letter matters beyond just the political fight. This isn't just a policy complaint from ICE. This is a legal paper trail. If California releases someone on this list and they commit another crime, ICE now has documentation proving they warned the state in advance. That's liability ammunition for future lawsuits or federal funding cuts. They're building a case, not just making a statement. But before we assume California is just ignoring federal law and releasing dangerous people into communities, let's look at what Sacramento is actually saying in response, because their numbers tell a very different story. Governor Newsom's office fired back immediately. They called the ACE letter fact-free and a political distraction. Their counterclaim? California has already transferred 12,229 individuals to federal custody since 2019. According to California Department of Corrections data, the state does cooperate on serious offenders. When someone in state prison is flagged for violent felonies, the state notifies ICE and arranges transfers. The problem isn't state prisons. The issue is nonviolent offenders in county jails. That's where sanctuary policies create the biggest gap between what ICE wants and what California will do. California also makes another claim that doesn't get enough attention. They say the feds are dropping the ball on their end. For every 8 people California makes available for ICE pickup, the federal government fails to collect one of them. That's a 12.5% failure rate. So Sacramento's argument is basically this: you want us to hold more people? Start picking up the ones we're already giving you. That's a fair question, and it complicates the narrative that California is just being defiant for political reasons. Here's the political calculation happening behind the scenes. Newsom is positioning this as a federal competence issue, not a state defiance issue. If he can prove ICE is disorganized and failing to do their own job, he shifts blame away from sanctuary policies and onto Trump administration enforcement failures. That plays well with his base and gives cover to county sheriffs who are caught in the middle of this fight. It's smart politics, but it doesn't solve the underlying problem. So who's telling the truth here? Honestly, both sides are cherry-picking data to support their position. ICE is highlighting the 33,000 pending detainers and the serious crimes involved. California is highlighting the 12,000 transfers they've already completed and the federal failure rate. Both of those things can be true at the same time. But the real question isn't about past cooperation. It's about what happens to these 33,000 people right now, today, now sitting in California jails. Let's talk about the actual offenses tied to these detainers, because this is where the public safety argument gets real, and we need to be honest about what we're discussing. 399 individuals have homicide or manslaughter charges. 1,293 have sexual offense charges, including assault and crimes against children. 2,300 have weapons violations. Thousands more have assault charges, domestic violence charges, DUI, drug trafficking. These aren't people who got pulled over for a broken taillight. These are individuals already arrested and charged by California law enforcement for serious crimes. Now here's the uncomfortable truth that makes this complicated. Some of these people will be convicted and serve time in California prisons. Some will be acquitted or have charges dropped because that's how the justice system works. And some will be released on bail while awaiting trial because they have a constitutional right to due process. The question at the heart of this whole debate is, should California hold them extra time for ICE even if a judge grants them release? That's the legal gray zone we're operating in. The due process argument says no. You can't hold someone without a warrant just because federal agents want to deport them. That violates their constitutional rights. The public safety argument says yes. If someone is here illegally and charged with murder or sexual assault, you shouldn't release them back into the community before ICE can intervene. Both arguments have legal and moral weight, which is exactly why this fight never gets resolved. But while Sacramento and Washington argue over legal theory, there's another group caught in this fight that nobody's talking about enough: local county sheriffs who have to make the actual custody decisions every single day. California isn't a monolith. It's not one unified state with one unified policy. Some counties are already ignoring Sacramento's sanctuary policies and cooperating with ICE anyway. Sheriff's departments in more conservative counties like Orange County, Kern County, parts of the Central Valley, they've publicly stated they'll honor ICE detainers regardless of what Senate Bill 54 says. Their legal argument? The sanctuary law applies to local law enforcement, but sheriffs can interpret that narrowly and still notify ICE when serious offenders are in custody. Some of them argue they have a duty to public safety that overrides state policy. This creates a patchwork enforcement map across California. If you're arrested in San Francisco, sanctuary policy applies and you probably won't be handed to ICE. If you're arrested in Bakersfield, you might get handed to federal agents the next day. Same state, same federal law, completely different outcomes. Watch for more counties to break ranks if federal pressure increases. Sheriffs are elected officials, and in red-leaning counties, voters want tougher immigration enforcement. If Trump's administration threatens to cut law enforcement grants that fund deputy positions and equipment, sheriffs will have political cover to ignore Sacramento and cooperate with ICE directly. They can say they're protecting federal funding and public safety at the same time. That means California's sanctuary policy could collapse from the inside, not through a court ruling, but through county-level defiance. And if counties start flipping, the financial consequences for California become massive, because this fight isn't just about detention anymore. ICE doesn't just want cooperation, they want compliance. And the Trump administration has a weapon they're very willing to use: federal funding. California receives billions in federal grants every year for law enforcement, disaster response, highway maintenance, emergency management, all kinds of programs. Under previous Trump administration policies, the feds threatened to withhold grants from sanctuary jurisdictions. Courts blocked some of those efforts back then. But the legal landscape has shifted with new Supreme Court rulings and a different political environment. The statement from Assistant Secretary McLaughlin ties this directly to public safety funding. The implication is clear: if California won't cooperate on immigration detainers, expect cuts to programs that have nothing to do with immigration. That's the leverage game. California can't afford to lose federal highway dollars or emergency management grants, especially with wildfire season and earthquake preparedness needs. But Newsom also can't afford to look like he caved to Trump on immigration, because his political future depends on maintaining progressive credentials. So the likely outcome is a behind-the-scenes deal where California quietly increases cooperation for violent offenders while publicly maintaining the sanctuary framework. Politicians on both sides get to claim victory. Watch for pilot programs or memorandums of understanding where certain counties agree to limited cooperation in exchange for continued federal funding. That's how political standoffs usually end, not with one side winning, but with a compromise that lets both sides save face. But while the politicians negotiate, there's a real-world impact happening right now in California communities, and we need to talk about it honestly. The core argument here isn't just legal, it's about community safety strategy, and there are legitimate competing concerns. Federal officials claim sanctuary policies endanger communities by releasing dangerous individuals before deportation proceedings can happen. They point to statistics showing that 7 out of 10 of the safest U.S. cities cooperate with ICE as proof that cooperation equals safety. Their argument is straightforward. If you hold serious offenders for ICE, those people get deported instead of released back into neighborhoods. California officials argue the complete opposite. They say sanctuary policies make communities safer because immigrants, including undocumented immigrants, are more likely to report crimes and cooperate with police if they're not afraid of deportation. If local cops start acting as immigration agents, crime victims stay silent, witnesses don't come forward, domestic violence victims don't call for help. And criminals operate with more freedom because the community won't work with police. That's their argument, and it's based on research from police chiefs in major cities who've seen cooperation rates drop when immigration enforcement increases. Both arguments have merit, and that's what makes this so difficult. The reality is probably somewhere in the middle. Sanctuary policies might improve trust with immigrant communities and increase crime reporting, but they also create gaps where individuals with serious criminal histories can slip through before ICE intervenes. The question for California voters is, what's the bigger risk? Undermining immigrant trust in police or releasing individuals with violent charges before federal authorities can act? There's no easy answer. All right, and anyone who tells you there isn't being honest about the complexity here. So where does this standoff go next? Let me walk you through 3 scenarios, and you can decide which one you think is most likely. Scenario 1. California holds firm and the feds escalate. Newsom refuses to honor detainers across the board. The Trump administration cuts federal funding to California law enforcement agencies. California sues in federal court, arguing the cuts are unconstitutional coercion. This drags out for months or years while lawyers fight it out, and the 33,000 detainers remain unresolved. Meanwhile, counties are stuck in limbo. Some individuals get released, some get picked up by ICE in raids, and the legal chaos continues. Scenario 2, partial compromise. This is where I think we're actually headed. Is California agrees to honor detainers for the most serious offenders, homicides, sexual crimes, major trafficking cases, gang violence, but they maintain sanctuary protections for lower-level charges and civil immigration violations. ICE gets some wins and can claim they forced California to cooperate on dangerous individuals. Newsom keeps his progressive credentials by saying he protected immigrants from deportation over minor offenses. Counties get clearer guidance on when to cooperate and when to refuse. The legal battles decrease because both sides got something they wanted. Scenario 3, county-level collapse. More counties rebel against Sacramento. Sheriff's departments in the Central Valley and Southern California start cooperating with ICE regardless of state law. California becomes a split enforcement state where your zip code determines whether you're subject to immigration holds. Sacramento loses control of the policy entirely, and we end up with dozens of different local approaches instead of one statewide policy. That would be chaos for enforcement, but it might be the natural outcome if federal pressure continues and sheriffs decide they answer to voters, not Sacramento. My prediction? Scenario 2 is most likely in the short term. Scenario 3 is most likely by 2027 if federal pressure continues and funding cuts actually happen. Scenario 1 only happens if both sides are willing to destroy their relationship entirely, which is possible but politically expensive for everyone involved. Politicians usually choose compromise over total war, even when they're talking tough in public. Now let me bring this home to what it actually means for you as a California resident, because that's what really matters here. This isn't just an immigration fight happening in Sacramento or Washington. It's a test case for how much control states have over law enforcement when the federal government demands cooperation. And the outcome affects you directly, whether you're a citizen, a legal resident, or undocumented. It affects you whether you care about immigration policy or not. California's sanctuary policy is based on a simple premise. Local cops shouldn't do federal immigration enforcement. That's the federal government's job, not the job of city police or county sheriffs. But when federal immigration enforcement includes holding individuals charged with murder or sexual assault, the line gets blurry really fast. Are we talking about immigration enforcement or public safety? Are we talking about civil violations or violent crime? The categories start bleeding together, and that's where the real disagreement lives. Both sides have legitimate arguments grounded in real concerns. ICE is right that some dangerous individuals are being released before deportation proceedings happen, and some of those people commit additional crimes. California is right that the federal government has failed to pick up thousands of people the state already made available, and that cooperation with immigration enforcement can undermine community trust in police. And both sides are absolutely using this standoff to score political points heading into the 2026 midterms and the 2028 presidential race. That's just the reality of politics. For you as a California resident, the practical impact breaks down like this. If you live in a county with a cooperative sheriff, immigration enforcement will be more aggressive. You'll see more ICE activity, more detainer cooperation, more people held for federal pickup. If you live in a sanctuary county, expect more federal raids because ICE has to do the work themselves without local help. Your safety depends partly on local policy choices, and those choices are about to get a lot more contentious and a lot more visible. So what should you watch for in the next 30 days? Because this story is developing fast, and you need to know what signals matter. First, track county-level responses. If sheriffs in Fresno, Riverside, or Sacramento counties make public statements about detainer cooperation, that signals whether California's sanctuary wall is cracking. Those are bellwether counties that could influence others. Second, watch for federal funding announcements. If the Trump administration starts withholding grants to California law enforcement agencies, Newsom will be forced to either sue or negotiate. That's when the real compromise talks begin behind closed doors. The public fight is loud, but the private negotiations determine what actually happens. Third, monitor court filings. If California or immigrant rights groups file lawsuits challenging the detainer demands, expect this to become a multi-year legal battle that ends up at the Supreme Court. We've seen this pattern before with other immigration cases, and this one has all the ingredients for a major constitutional fight. And finally, keep an eye on state legislation. If Sacramento Democrats introduce bills to strengthen sanctuary protections, that's a sign they're digging in for a long fight. If they introduce bills creating exceptions for violent felonies or serious crimes, that's a sign they're preparing to compromise and looking for a middle ground. This is the kind of story that develops fast and gets buried under national news cycles if you're not paying attention. The mainstream outlets will cover the initial letter, maybe do a follow-up when something dramatic happens, and then move on to the next controversy. But the real story happens in the weeks and months after, when counties make decisions, funding gets cut, deals get negotiated, and policies actually change. If you want real-time updates on how California's immigration standoff evolves, not the sanitized versions from mainstream outlets, but the actual policy moves and funding threats, you're in the right place. Subscribe if you're serious about understanding California politics before the decisions hit your community. I'm not here to tell you what to think about immigration. I'm not here to pick a side for you. I'm here to give you the information you need to make up your own mind and understand what's actually happening in your state. No fluff, no filler, just the intel you need to stay ahead of the curve. Next video drops in 48 hours covering the latest budget updates and what Sacramento isn't telling you about the deficit. Don't miss it. I'll see you then.